Your Honor, I'm not sure if you're addressing the parties appearing remotely right now, but your microphone is muted, so we've not been able to hear anything.
Well, hearing no objection from Mars or Nelson, I will grant Tier 4 the relief they requested. Thank you, everyone. Gotcha. I apologize for the microphone issue. I just gave a great speech summarizing what I thought the case was about, not taking any sides, just saying there's a non-compete, et cetera, which I will repeat in a moment. I did not realize that our podium, that's actually the microphone that pushes sound throughout the Zoom system when we are on, that microphone was off. And so I'm going to ask Madam Court Reporter and counsel for Tier 4 to bear with me as I do my best to repeat myself. I'm still Judge McBurney, but everyone out in the hinterland should be able to hear that now. And we are here on 25 CV 010022, which is a suit between Robinson Key, which I'm going to call Tier 4, against Mr. Nelson and Mars IT. I'm going to call them Mars. And we're here today just to focus on the motion for immediate and emergency temporary injunctive relief that Tier 4 filed pursuant to what they contend is a binding set of non-compete covenants that Mr. Nelson entered into as part of his employment contract with Tier 4, which he abruptly and surprisingly to Tier 4 ended in May of this year, and Tier 4 points to these clauses about non-compete, and they point in particular to Northwestern Mutual as a Tier 4 client for whom Mr. Nelson is now doing work that is inconsistent with the limitations he voluntarily agreed to in terms of the kind of work he could do for the first 12 months after he left the employ of Tier 4. And I've received several affidavits, done my best to read them. Some just hit, so I've skimmed them. But it sounds like we're going to be proceeding mostly through the presentation of the affidavits, although I see at a minimum we've got Mr. Nelson on the call, so it may be we hear from him a little bit. But that's all we're working through today. It's the merits of the case only tangentially, because that's an element I have to weigh in considering whether to grant the requested equitable relief. But the focus is the request for temporary injunctive relief during the pendency of the case, although no longer than 12 months after Mr. Nelson left Tier 4. I would hope we finish the case before then, but who knows? So that's all I said when the microphones weren't working. And then someone said, hey, they can't hear you. So I've now said it twice. And then I was asking, let me know who's on for each client. And that's when we turn the speaker on. So here on behalf of Tier 4 is whom?
Good afternoon. This is Megan Noble, Your Honor, on behalf of Tier 4.
All right, Ms. Noble, thank you for being here. Do we have anyone on the call for Mars?
Yes, Your Honor, Christopher Rosser.
All right, there you are. And how about for Mr. Nelson?
I see Curtis Campbell, but it looks like he's muted.
Yeah, good call. It seems like everyone's having issues with their mics. Curtis Campbell on behalf of Mike, Your Honor.
Fantastic. Thank you all for being here. We'll get started in just a second. So I've given you sort of a procedural overview. My understanding from reading the pleadings is that Mr. Nelson was with Tier 4 for a bunch of years, started in 2019, which means he was there for about 6 years. And I don't get the sense there's any dispute about the fact that he signed a non-compete and confidentiality agreement. As I understand the dispute, is he violating the terms, those covenants basically that he entered into So it's not it's overly broad, it's geographically too broad, or it lasts too long. It is whatever Mr. Nelson is doing today is not inconsistent with the restrictions to which he agreed when he joined the Tier 4 workforce. But you guys will flesh it out. You're the advocates for the various sides. And I just want to give you all an opportunity to be heard on that front. And then we'll figure out how best to move forward. So before you dive into anything, Ms. Noble, is there anything procedurally you want to correct? Like McBurney, no, it's not. We're actually not even here on a TRO.
No, I think we're good.
Okay. Mr. Rosser, anything you want to add?
No, Your Honor. I think your recitation is generally accurate.
Okay. Well, I gave it twice, so maybe it got better the second time. Mr. Campbell, anything procedurally on behalf of Mr. Nelson?
Not procedurally, just quickly though, I would say that I would not say that we are agreeable that the contract is not overbroad.
Okay, and I really shouldn't have dipped my toes into that water. No one's waiving anything by going forward with the TRO argument. You may have very meritorious challenges to the restrictive covenants. My skimming of them, it struck me that they seem pretty routine. Certainly the duration doesn't seem to be outside the norm, but it may be the scope is something that you want to touch on some today and then challenge more substantively in the future. But by moving forward today, no one is waiving some claim that the covenants aren't binding because they're contrary to policy and law. All right, Ms. Noble, get us started, please.
Thank you, Your Honor. I won't repeat what you just said because I agree with it. We're here seeking to enforce the restrictive covenant agreement that our former employee, Mike Nelson, who was Director of Client Services for 6 years at our business at Tier 4, left our employee rather suddenly and immediately.
Can you tell me the title again?
He was Client Services Director at Tier 4.
And what does that mean?
Basically, he was obviously concerned about developing clients, increasing market share, but also he had a lot of recruiters who reported to him. He was part of the executive team. There's actually a very helpful job description attached it's submitted as an exhibit, which I could give you, which kind of outlines exactly what he did. But it was more than just sales. He was also on the leadership team and part of developing Tier 4 going forward.
Okay, and I omitted this from my summary. Tier 4 and Mars, I think, but definitely Tier 4 is a talent acquisition firm, not meaning it acquires talent for itself, but if McBurney Enterprises needs an IT professional, rather than me doing an Indeed thing and whatnot, I might hire Tier 4 to say, hey, we need 3 people to do these kinds of things in the IT field. Can you help us find them? And then Tier 4 would do that, make some money off it. But what the service Tier 4 is providing is here are some candidates for the job.
And that's exactly correct. You're
okay. And Mr. Rosser, does Mars do something different than that? Because it's easy. If Mars is a tuna canning plant, then it seems like we don't have to spend a whole lot more time on this.
I think it is accurate to say that Mars provides talent acquisition services. I think the scope of industries that they service is broader than the industries that Tier 4 services, although that's based on my very limited review of the information that we have available at this time. Obviously, we haven't conducted any discovery, so I'm saying that based on my limited knowledge at this point.
Okay.
But yeah, generally speaking, it is correct. Mars is a talent acquisition firm.
Okay, and let me ask it more pointedly. It's no longer McBurney Enterprises. I work for Northwestern Mutual. Would Mars be in a position to assist Northwestern Mutual in talent acquisition?
Yes, Your Honor, it would. In fact, Mars has had an MSA. They've had a business relationship with Northwestern Mutual specifically since September of 2018. And that fact is described in the affidavit submitted by the CEO of Mars, Rashi Khosla,
Okay, and you'll be able to dive deeper with that when it's your turn. I just want to make sure, as you were saying, Mars's footprint might be broader in the talent acquisition field. However broad it is, it steps on insurance. I think that's what Northwestern Mutual is an insurance company.
I'm not really sure what exactly Northwestern Mutual does, but
Well,
yes.
whatever they do, Mars services them.
Yes, correct.
Okay, and Ms. Noble, it's very plain from the affidavit from Ms. Robinson Hicks. Tier 4 also provides talent acquisition services for Northwestern Mutual.
That's correct, Your Honor. They're very much competitive with one another, both relatively small woman-owned firms that compete for the same big fish, which is Northwestern Mutual.
Okay, if I were the head of HR or recruitment or whatever it would be called at Southwestern Mutual, so another big fish out there, would I have heard of both Mars and Tier 4, or is this such a fragmented industry that it's not like, there's Chevron and we need to get gas at Southwestern Mutual, so we're going to go to BP or we're going to go to Chevron?
I can't speak necessarily for the industry, but I know that they're both large players in the industry. They both attend the same conferences, know the same people. There's a lot of overlap, obviously, in terms of the people they're competing for. That's never been in question.
Okay, and that they know of each other. It's not that Mars learned about Tier 4 only after they hired Mr. Nelson. Tell us about Tier 4. Of course, he would say, I can't tell you about it because I'm bound by the confidentiality agreement. Okay, all right, that's helpful. So back to you. Both are talent acquisition firms, and Mr. Nelson was the client services director at Tier 4, which meant he was part of the executive team.
That's correct.
Okay.
So after he left, we started Tier 4, and I'm kind of jumping ahead, going right in the affidavit as you suggested. After Mr. Nelson left our employ, pretty quickly, people at Tier 4 started hearing things about him doing a lot of work immediately with Northwestern Mutual. The affidavit that we submitted from Betsy Robinson, who's the president and founder of Tier 4, mentions that on June 4th, she was at an industry conference, and she was told by an employee at Northwest Mutual that she had received an email from Mars CEO indicating that Mr. Nelson would be the new point of contact for their needs. Subsequently, Tier 4 was attempting to place an employee that Mr. Nelson had placed at Tier 4 at Northwestern. When they attempted to place the employee, Northwestern said, hey, sorry, we can't take this. Somebody else had placed it. And it turned out that Mars had placed it. Now, the reason that
I want to make sure I understand that.
Yeah.
So John Doe is someone who wants to get some IT work.
Right.
And Tier 4 is marketing him as an IT resource to Northwestern Mutual. And the Northwestern Mutual people say, well, we already hired John Doe. Why are you offering him up? He now works for us. P.S. We got him through Mars's contract that we have.
That's correct.
Okay. If I'm John Doe looking for a job, can I give my information to Tier 4 and Mars just to double the likelihood that I might land a job somewhere? It might cost me more, but it gets me more exposure.
Absolutely. There's nothing that would preclude that, nor would anything preclude Northwest Mutual from hiring whomever they want from either company.
Okay. The concern from your client is, look at this coincidence. Mr. Nelson switches teams, someone that in effect he would have been trying to peddle to Northwestern Mutual wearing his Tier 4 hat, now has been hired by Northwestern by someone with a Mars hat. Whether it was Mr. Nelson or not, look at what's just happened.
And we have no direct evidence that Mr. Nelson did it, but what we do have is some inferential information that we've received, which is the employee who was placed initially by Tier 4 was working remotely. However, she lived in Madison, Wisconsin, which is about 80 miles away from Milwaukee, where the position was. That's when Mike Nelson placed her for Tier 4. The reason we think that he was involved in pushing her as a candidate for Northwest Mutual is because, according to our folks, a normal search for candidates wouldn't go 80 miles out of the city. And so we assume that because he had a pre-existing relationship with her, he had onboarded her, he was aware of it, he may have recommended her for the hire. Now, we don't know that, but that's what we've seen. And we've also, as I said, talked to many Northwest Mutual employees have come up to our people at different times saying, hey, we're being told that, like Mike Nelson has called us saying he wants to meet us. He's our new point of contact. And we know we've lost for sure the one placement that we had that we would have had otherwise, but we don't know what else we're losing at this point. And that's kind of where we get into the need for the injunction. You know, as you know, the Restrictive Covenants Act allows, if it's a valid and enforceable covenant, for an injunction to issue. And it's important to note also that Mr. Nelson agreed to an injunction specifically and expressly in the agreement he signed.
That's the relief that would be provided if an issue arose.
That's correct, for the breach. So he signed that, he contained it, he was good with that. You know, as I said, they're both, Tier 4 and Mars are both large competitors. But based on the information we've been getting from Northwestern Mutual through our employees, it sounds like he's being presented as being more involved than what he's represented. I'm not disparaging him. I'm just saying he seems to be involved doing the same things he was doing, at least for a portion of his time when he was working for us.
Sure. No, everything you describe is someone who is doing his job. He's just doing it for a competitor, which from your perspective is inconsistent with the restrictive covenants he agreed to.
That's exactly right. Because you don't get more direct competition than going for another IT recruitment provider immediately after you leave the one working with the same clients and the same people.
Okay. You just used the plural, clients. Northwestern Mutual seems to be the poster child for your concerns.
That's correct. It's our largest client, or it had been, and Mr. Nelson worked extensively with them during his tenure at Tier 4.
Okay,
And
so that's why it features so prominently. It's not just a client, it would be the premier client
Correct.
For Tier 4.
And there are probably 15 or so other clients that he would have met the material contacts requirement for during his tenure there. That, you know, as we go through this, we'll get more information about, but and can provide more information. But Northwestern Mutual, the interactions with them are the only ones that we're aware of at this point that prompted us to file this motion.
Okay, all right.
And so because we have a valid non-compete, we feel that we're entitled to receive injunctive relief because we're facing immediate and irreparable harm in the face of losing business relationships and our status with Northwest Mutual. There's a case, particularly Heartland Payment Systems versus Stockwell, which is 446 F Sup 3rd 1275, basically where they're saying that you can, it's a legitimate thing to enforce an agreement. People are if somebody's competing directly for a competitor that he knew of during his old employment. So there's definitely precedent for granting an injunction in a situation like this. His restrictive covenants are very short. It's only another, it goes till May of next year, and there's no tolling provision. So we're not talking a long amount of time.
Right, 9 more months.
Exactly. He also expressly agreed in the agreement that it was reasonable, that he understood he could get another job elsewhere, and that he just couldn't work for those particular clients and people that he knew with Northwest Mutual. We feel like he is, with Tier 4. We feel like he is just parlaying his experience now to benefit his new employer, and that they are touting him as having experience with them, and he's their new person. He may be doing things other than just sales there, but he did things other than sales for us too.
Okay. Was it also part of the non-compete agreement that Mr. Nelson entered into that he agrees that it is in fact irreparable harm to your client if he violates the non-compete?
Yes, Your Honor. That's expressly stated in the agreement that he agreed that it would be irreparable harm to the extent this was breached. And that's in Section 4 regarding enforceability, and also in Section 5B, where basically he's talking about irreparable injury specifically, that he agrees in the event of breach. And he just signed this in February of this year, so this is not an old agreement.
And he signed it only in February because until then there were no non-competes, or this is a new and improved non-compete?
It's a new and improved.
Okay.
So I would say we've met the standard for getting an injunction because we have a valid and enforceable agreement. Tier 4 is experiencing irreparable harm, and the loss of that client goodwill with its biggest client is significant. Nelson agreed we could get injunctive relief in the event he violated it, and we are aware of at least one lost placement opportunity that directly harmed us there. We feel like we have a good likelihood of success on the merits as we go forward with this. We're going to have to obviously do forensic searches of emails and to verify. We don't have any of that at this point.
Okay.
But that's why we're looking just for an order prohibiting until May 2026, him from competing with us and from soliciting our clients using knowledge he had before he left Tier 4.
Okay. And are you comfortable, and we need to see how this plays out if I do grant relief, Mr. Rosser and Mr. Campbell would need to know, well, who are the clients we're talking about? Your client has been comfortable identifying Northwestern Mutual as one, but when I've had these disputes before, sometimes the plaintiff has said, and he can't compete against any of our clients, and we're not going to tell you who the clients are, because if we do, he'll compete against them. And I'm like, well, I don't know how we enforce that. Obviously, Mr. Nelson would know who were clients when he was there, and if there's a new client for Tier 4, he isn't violating anything if coincidentally Mars is going after that client as well. So it's known or was known to him, but the lawyers are going to need to know. And I don't expect Mr. Nelson to be able to say from the top of his head, these were the 39 clients with whom I had meaningful interactions when I was at Tier 4, because it could be 300 clients. I don't know. And client isn't just Northwestern as a client, but Sally Smith, who's looking for a job, is a client. And that seems like it could be hundreds.
That's correct. We have had some discussions with the other side about which clients, and we would have no issue providing a list of specific. We've run through his work. We can have a specific list. I think there were about 15 or 20. Curtis, you correct me if I'm wrong. I think I gave you a list of maybe 15 or 20 potential clients at one point that were of concern in addition to Northwest Mutual.
Okay.
So we would have no issue with that.
Those clients are the companies who are looking to hire, not the would-be employees.
Exactly. The would-be employees can go with whoever they want. It'll probably make sense to go with more.
Yeah. Okay. Last question for now, but as the movement, you'll get to have the final word when we wrap up. Most of the relief you're seeking is border directing, prohibiting, et cetera. The fifth, the E, is give us our stuff back. And in Mr. Nelson's affidavit, or someone's affidavit from the defense side, is like, I didn't take, I gave you I took nothing other than what's in my head. Now, in this day and age, that's tricky because he probably also took his personal cell phone and who knows what's in there. But I'm wondering if there was something concrete that Tier 4 had been telling you he has the Tier 4 Rolodex.
Your Honor, I don't think he's got the Tier 4 Rolodex. We felt like perhaps he took some information regarding potential recruits, or at least maybe he just remembered this particular recruit in Wisconsin.
The Madison person.
Exactly.
Okay.
that's the only thing we have at this point. We don't have anything more than that, so
Okay.
nothing concrete.
All right, got it. Because again, I've had cases where it's like, no, he didn't return his laptop.
Right.
And so part of the order was, and I go, I had to be the one who received it because they didn't want to come in the building, all that kind of stuff. Good. Okay. Mr. Campbell, Mr. Rosser, either one of you can go first, but I would like to hear from at least one of you on the defense side.
And I can start off. Curtis Campbell on behalf of Mike Nelson. And Your Honor, I think you said it perfectly. Look at this coincidence. There is no direct evidence. Opposing counsel said it is inferred that this employee was placed. It felt like there must be a breach, Your Honor. There must be direct evidence of a breach. He said, she said, who said is not enough to grant injunctive relief. This is not about a former employee taking clients, using trade secrets, breaching contractual promises, taking a Rolodex. It is about unsupported accusations upon information and belief and hearsay by people named senior director and contingent labor leader.
Well, let me push back a little bit because the lawyers asked, and you may not have been part of the discussion. I don't know. This was with my staff attorney, and I know you're parachuting in late because Mr. Nelson was extremely hard to serve, which I thought was peculiar, but it is what it is. We have affidavits, so yes, it's going to be one step removed, but let's assume for a minute that someone from Northwestern Mutual was subpoenaed and came in here and said, yeah, I got this email from the head of Mars who said, hey, the new point of contact for any recruitment needs we have at Northwestern Mutual, if we're going to work with Mars, is this new guy, Mr. Nelson.
Your Honor, that would
be. Do I have to say anything more before you would say, if you were in Tier 4 shoes, what?
But Your Honor, that's the problem, is we need that person here to provide that email to show that that's what happened. You're a judge, and I'm sure you've seen plenty of scenarios where people will say one thing and another thing has happened. And that's what I mean. We need direct evidence, not hearsay. This person heard from this person who's not named.
All right. Well, I hear you on that. I don't know that that's going to carry the day today. So let's shift to assume for a moment that, in fact, the CEO of Mars sent to the appropriate people, the customer connections at Northwestern Mutual, an email that introduces Mr. Nelson as the new point of contact for any of Northwestern Mutual's recruitment needs. Assume that's true. How is that okay?
But again, Your Honor, that's assuming that happened. And Mike Nelson is here to testify that did not happen.
Well, Mike Nelson didn't email it, so Mike Nelson isn't the person to say that it didn't happen. It doesn't say it was an email from Mike Nelson. It was the CEO of Mars. Maybe he's also the CEO of Mars, but if he's not, then you'd offer him up for hearsay, which is exactly what you don't want right here. So you're dodging my question. Hear my question again and answer it as best you can. Assume for a moment that in the next day, Ms. Noble is going to be able to get all of us an email from the CEO of Mars that says, this just in, we've got a great new guy, excited to welcome him to the Mars team, Mr. Nelson, and he is your point of contact for any recruiting needs. Assume I get that email tomorrow. One, your client's a liar based on what you said. I don't believe that's true. But if it says that, my question to you is simply, how is that okay given these restrictive covenants?
Your Honor, if a email is provided that my client, Mike Nelson, is client facing, then yes, that is.
Okay. Good.
Your Honor, if I may, I think I may be able to address that question.
Well, as long as Mr. Campbell doesn't mind, I want to let him finish. He was making important points about the fact that we're proceeding on affidavits, which I requested so that we could fit this in today. And so I didn't mean to cut him short. I did interrupt him because some of what's said seems very easily provable. If Ms. Noble can't get to us in a day or so, emails that are described here, then she needs to have a real serious conversation with her client who averred in an affidavit that those emails exist. And I have no reason to doubt that person. And so maybe, Mr. Rosser, you are actually going to fill in that gap, because these don't say Mr. Nelson did anything. It's that Mr. Nelson was presented to people in a role that, at least as it's described in the affidavit, is fundamentally inconsistent with the agreement he entered into to not compete with his former employer.
And if and Chris, you can join it. And again, Chris represents Mars. I represent Mike, and there are affidavits and contradictory statements indicating that that is not the case here. And that's part of the problem, is we have not even filed a responsive pleading to the answer. We don't have the evidence. So that's why, I mean, even if we need to move forward on this injunctive hearing, we need evidence first, and we need to properly prepare for this hearing. And again, just going back to the affidavit, and Mr. Nelson is here to answer questions as necessary. Since leaving Tier 4, he has not solicited any Tier 4 clients, including Northwestern Mutual. He has not provided any recruitment services to Tier 4's clients. He has not solicited any Tier 4 employee. And opposing counsel mentioned that they lost for sure this placement. There is no evidence that Ms. Miller was even placed in a position. And that's part of the problem. No direct evidence. The harm here is hypothetical, and under Georgia law, speculation is not irreparable injury. We need evidence of a breach. And on top of that, any actual economic loss, such as even if Ms. Miller was placed, could be remedied with damages, making injunction unnecessary. And on top of that, and this is part of the problem of entering this restrictive covenant. The employee place was 80 miles away, and it is inferred that my client was involved. Your Honor, any time that there is contact with someone that was also in contact with Tier 4, and it was already pointed out that it is okay, unless there's an agreement with Tier 4, if someone is open to work on LinkedIn, you can reach out to them and say, hey, can we help place you? There's job boards, they can reach out and help place you. But that's the problem if you enter an order concerning this, is any coincidence, anything that can be inferred to my client becomes problematic. And here, the equities do not favor entering injunctive relief because that impacts my client's ability to make a living. The only conduct my client did to harm Tier 4 group was submitting his resignation because he was their top performer. Plaintiff cannot meet its burden on its likelihood of success before we even get to whether the territory as described is overbroad or the other terms that could potentially be found to not be enforceable. There is a sworn affidavit rebutting the claims of the plaintiff. Preliminary injunctions, as you pointed out, are not to resolve factual disputes or to give one side a pre-trial victory based on assumptions. Now, plaintiff in her affidavit reasonably believes that my client is familiar with Sarah Mailer. And if you would like to, we can ask Mr. Nelson this, but my client is willing to inform you he is not familiar with Miss Miller. He does not have her contact information. He did not reach out to her. He has based on his affidavit, both based on discussions, done everything to ensure that he stays within the confines of that agreement. He has taken steps to ensure that he does not contact anyone that he had previously contacted with Tier 4 group. Plaintiff has not shown evidence indicating otherwise. And on top of that, my client can testify that he is not aware of any contacts with Northwestern as provided in plaintiff's affidavit. My client has not solicited business from Northwestern, has not introduced himself as the point of contact with Mars, and he did not say he was the key account representative. Plaintiff relies on hearsay. We have my client here to testify to show why hearsay is inadmissible for a reason. I understand our time is short, but if you'd like to hear from my client, he is available. Otherwise, we just ask that this motion be denied.
What's the harm to Mr. Nelson and Mars if Mr. Nelson isn't interacting, he's not client facing, I think was your phrase, with any of Tier 4's current or former or potential clients of which he's familiar, of which he was aware? If he's not doing that, then the injunction would seem to cause zero harm on his side of the ledger, which is a factor I need to consider. I guess it would just be a judge saying, follow the covenants, which you're saying he is to a T. One response would be, well, you don't need to because there's no violation. Why would you impose an injunction? But if you're so sure there's no violation, why do you care if I put the injunction in place?
Your Honor,
it would ask him to not do the things that you say he's not doing. Might be a waste of paper, but I'm curious.
Your Honor, because what's going to happen is anytime that there can be a coincidence or an inference, as we're hearing today in this courtroom, that my client contacted someone that Tier 4 has reached out to, that Mars has also reached out to, there's going to be this light bulb, oh, it must be Mike. an injunctive relief is an extraordinary remedy, and there must be proof of a breach. It's not we can just enter it because he's not doing it. That's not how it works. There must be direct evidence of the breach and that they will be successful on the merits. It's not just for the sake of enforcing the agreement. It's if there's a breach, Your Honor.
Okay, I agree. I appreciate that answer. Let me hear from Mr. Rosser. He seems anxious to fill in the blank here about this supposed email.
Thank you, Your Honor. Well, as an initial matter, I don't want to rehash it, but I agree with Mr. Campbell that the affidavit submitted by the plaintiff relies on hearsay. So as an initial matter, I don't think the court should rely on those statements. In particular, I'll point out the paragraphs 12, 13, 14, 15, 16, and 17 that rely on hearsay statements. But with respect to the court's question about an email from, I think the hypothetical was the CEO of Mars.
Well, it's not a hypothetical. Let's go through paragraph 12. I don't disagree with you that paragraph 12 from Ms. Robinson Hicks's email contains hearsay. Mr. Campbell was spot on. She was in Milwaukee. She was told directly, these are her words, not mine, by a Northwestern Mutual employee that the CEO of Mars, so it's not a hypothetical person, CEO of Mars, Ms. Mars, had emailed Northwestern Mutual introducing Mr. Nelson as the new point of contact for any of their needs. And I assume that's not janitorial needs or insurance needs. It would be recruitment needs. But to Mr. Campbell's point, you don't have that. Well, you may have that email as the Mars guy. I don't have that email. I bet I'll get it in a day or so because I'm going to ask for it. And then Mr. Campbell will get it as well. I bet it wouldn't be a complete surprise for Mr. Campbell because if it exists, it'd be weird if Mr. Nelson wasn't copied on it, and then he'll have some explaining to do. But it's not a hypothetical. It either happened or it didn't, and it's paragraph 12. So walk me through paragraph 12.
Well, the issue with paragraph 12 is...
well, it's hearsay. There's that.
Yes, I mean, as far as the substantively.
Right.
Paragraph 12 says... this person was told by a Northwestern Mutual employee that the CEO of Mars had emailed. Okay, let's stop there. The CEO of Mars is not subject to the restrictive covenants agreement that plaintiff's claim is based on here.
Okay. I don't disagree with that, but that doesn't clear it for Mr. Nelson. Keep going.
I agree with you. It doesn't necessarily implicate Mr. Nelson unless it says that this email was sent at his direction, which it doesn't. But here's the thing. We cited a few cases in our response brief on page 7. I direct the court's attention to Vulcan Steel Structures Incorporated v. McCarty. That's 329 Georgia Appeals 220. We also cited Burson v. Milton Hall Surgical Associates LLC. That's 343 Georgia Appeals 159. Solicitation requires some type of affirmative action by the party who is subject to the restrictive covenants. Okay. In other words, if the plaintiff's allegation is that Mr. Nelson violated a restrictive covenant, then Mr. Nelson must have been the one to take an affirmative action to obtain business from Northwestern Mutual. That's not what the affidavit says.
Okay. No, it doesn't say that. But surely, I'll tell you how I'll rule on it if it's before me. You can't thwart the restrictive covenant by going to the new employer and saying, hey, man, I can't send this email. But you send the email and say, Mike's the guy. Here's Mike's phone number, et cetera, et cetera. But it's protected from a violation because whether it's the CEO or just a direct associate, and it may be a direct associate of Mr. Nelson sending it, it is nonetheless another company, a rival company, a competitor, soliciting business from Northwestern Mutual And the dangle, the attraction is Mr. Mike Nelson. And unless he had no idea it was happening, then wouldn't he, and you're not his lawyer, you don't need to answer this, but you gotta be saying, hey, CEO, knock it off. I can't do that. You can't use me in this way. I can't use me in this way because that was my client before. I can read. I know what I signed. I only signed it in February. I signed it 3 months ago saying I won't do this. And here you are doing this. And that's not why I came to Mars.
I acknowledge that Mr. Nelson, if as the hypothetical, if the hypothetical played out that way, that Mr. Nelson said to the CEO, "I can't send this email, please send it for me," then we may have an issue. But again, that hypothetical is based on facts that are not in evidence, and we actually have Mr. Nelson here today who can testify as to whether or not that conversation occurred. I suspect it did not.
Okay. All right. Was there more you wanted to add on the Mars side?
Well, again, Your Honor, I don't think there has been any proof here of any imminent or actual or threatened injury. I think the plaintiff's claim is based on conjecture. The timing of this apparent placement of Miss Miller seems to be coincidental with Mr. Nelson's change of employment. But what we don't have is anything tying any actual evidence of actions of Mr. Nelson that would suggest a violation of the restrictive covenants agreement.
Okay.
I think in the absence of a demonstration by the plaintiff with admissible evidence of irreparable harm or the threat of irreparable harm, an injunction cannot issue. In fact, the Georgia law is clear that in the absence of evidence supporting all four elements of a preliminary injunction claim, it is error for an injunction to issue. And we cited in our brief on page 6, the case of Glass versus Faircloth. That's 363 Georgia Appeals 232. It's a 2022 case for that proposition. It's stated directly in the case and in many, many others.
Okay. I have a question. I think it's for, oh, he disappeared. Mr. Campbell, where'd you go?
I'm still here, Your Honor.
Okay. You got a different look now. You're on a pier or something.
My computer died.
Okay. You got it plugged in now?
Yeah, I'm good, Your Honor.
Excellent. I think it's a question for you, Mr. Rosser. You should feel free to chime in. How do you two, or you in particular, Mr. Campbell, navigate the contractual language that Mr. Nelson entered into that says if there's a breach, injunctive relief is appropriate, and if there's a breach, it's irreparable harm. You don't need to press me on it. I agree. If I breach one of these restrictive covenants, it's irreparable harm. Now, I get it that both of you are saying there's no evidence of a breach. There's hearsay, there's inference, et cetera. So I don't need to hear that again. I'm following that argument. But if I find there's a breach, and one of the things I'm going to ask Ms. Noble for, her paragraph 17, well, it's not her paragraph. The CEO of Tier 4's paragraph 17 of her affidavit says, I was in Milwaukee and was told that my other leaders at Northwestern Mutual, I assume it's other leaders at Northwestern Mutual, that Nelson had been reaching out to them to meet. So there ought to be a way that Ms. Noble's going to be able to get a statement from someone who says, here's what Mr. Nelson said. Not hearsay, statement of a party opponent. So if she can get those things and this email, then there's going to be a little less speculation, a little more concrete. It may be proof of nothing, but we'll have a little more of the substance to which you are entirely entitled, Mr. Campbell and Mr. Rosser. But assume that in sussing through that, I say, gosh, this just seems inconsistent with the covenants. And so I think that, for example, the outreach, just assuming it happened, that two people from Northwestern Mutual say, yeah, let me tell you what Nelson did. He called me up, he said, I'm at Mars now. I'm here to help you with recruiting. So that's an affidavit from a Northwestern Mutual person saying, here's what Nelson told me, not hearsay. And I deem that to be a breach. Why do I need to do anything more than that before issuing an injunction, given what Mr. Nelson agreed to in his contract, that a breach merits an injunction and a breach constitutes irreparable harm? Because part of your argument, and it's a good argument, Mr. Campbell, was, hey, a lot of this can be monetized. And if you can monetize the harm, then you don't give equitable relief. If in the end, Mr. Nelson or Mars is liable, it's for $52,000 and you don't impose equitable relief. But we've got the terms of this agreement that say, yes, you do. If someone finds that there's a breach, injunction is appropriate and the harm is indeed irreparable. Doesn't matter what Mr. Campbell thinks or Judge McBurney thinks.
Well, Your Honor, first, we would need to determine whether or not it's appropriate to even contain that provision. And I'll just give you a quick example. So let's say that in the case of a breach, we get to tie you to a pole and you get to work for us for 20 years. Obviously, that wouldn't be appropriate. So first and foremost, it's determining whether or not that provision is even enforceable. And even on top of that is whether the agreement is enforceable as well. Just as an example, you mentioned it earlier, the word territory, whether or not it's overbroad. So it's also determining whether or not the agreement as written is enforceable. So even if you find that there is a breach, I don't believe any evidence has been indicated otherwise, but even if we find there's a breach, it's whether or not it's enforceable. And that goes to the piece of whether or not that there's a likelihood of success at a likelihood of success. Now, if we find out that there is this magical email out there, I would believe that the next piece would be to brief on the issue of whether or not the agreement is enforceable, because otherwise it would be entering an order on an agreement that may otherwise be found unenforceable. And again, responsive pleadings have not been filed. I accepted service on behalf of my client 2 days ago, so this is still early. I have not had the ability to properly review this agreement to determine whether or not it is enforceable. So even if that email is out there, there's still further factors and further bits of information that we would need to determine whether or not we can even enforce those provisions.
Well, given your skimming of the employment agreement and the discussion we've had, what's your 122nd response as to why it would not be enforceable? Because you've mentioned territory several times, and it may be that part of the territory is too broad because it says Asia and Tier 4 doesn't even operate in Asia. But what we've bumped up against is something that would seem to fall into the heartland of any enforceable agreement, which would be a current client. It's not territorially limited. It's, hey, it's Northwestern Mutual, and here you are trying to service Northwestern Mutual wearing a Mars hat instead of a Tier 4 hat. And that would seem to fall pretty safely into the heartland of the covenants, where we don't need to worry about Asia or a different industry that Tier 4 doesn't normally operate in for recruitment.
And Your Honor, again, that's part of the problem I'm having with this hearing in the first place is I don't have solid ground to stand on to properly rebut this. And when it just going to the territory piece in and of itself, already there's language in there indicating it's overbroad. Now, can we cut certain pieces of it to put it within that provision? Sure. Is that appropriate under Georgia law? That's something that should be briefed.
Okay.
So long story short, I can't give you a 120-second speech on why it should not be enforced, but that's, again, part of the issue. We have not had an opportunity to obtain evidence and to properly review this agreement and brief the issue.
Okay, I hear you. It's why it's an emergency motion. That's why we're doing it up front. And should I take any action, none of it is irreversible, such that as you have more time and get more information, there's nothing we couldn't revisit when you reach a point where, hey, now I need to bring this concern, Judge. You took step X, and here are 3 reasons why that was in error, and we are urging you to reverse your movement in step X. And I'm always open to that as well, but you've been through this. Yes.
Just briefly, I just want to say that, injunctive relief is not cautious relief, it's extraordinary relief. So that would be my only response to that piece.
Okay, got it. Mr. Rosser, anything you want to add in connection with the question about the enforceability of the restrictive covenants? Your early impressions, because I get it, it's early on.
Yes, understood, Your Honor. Just one thing to add, and that is if the plaintiff demonstrates entitlement to injunctive relief, it is incumbent upon the court to narrowly tailor the relief to protect the plaintiff's rights first, but second, to do no more than is absolutely necessary to protect those rights. The order cannot unduly burden the enjoined party. We've cited cases in our brief for that proposition on page 6, Rigby versus Boatwright, 330 Georgia Appeals 181, DBL Incorporated v. Carson, 262 Georgia Appeals 252, and I believe we cited a couple of others there. So I think it does somewhat tie in with what Mr. Campbell said, and the issue is that there will be some difficulty in determining exactly what scope of relief would be appropriate. So without rehashing the point that it is at this point, frankly, just too early to make those determinations. Yeah, I don't think we have enough information at this time that would allow the court to narrowly tailor any relief.
I hear you on that, and were I to move forward with any cautious, extraordinary injunctive relief, Ms. Noble would start with the pen and draft, this is what we have in mind, but it would then need to go across both your desks so you could highlight for me areas of concern, not Judge, we don't think you should do this, because if we are going through that exercise, I've already decided we're doing it, but it would be to address that very concern that the injunctive relief not be overly broad. And just like Mr. Campbell, I haven't been able to digest all the terms and conditions, so I couldn't say right now, yep, I'm going to grant relief, and these are the contours of that. But there's some obvious ones, like knock it off with Northwestern Mutual, if that's what the evidence shows. And so it could be that the initial relief isn't broad enough, but at least it gets relief in place where it ought to be, should I so conclude. Ms. Noble, you've listened quietly to Mr. Campbell and Mr. Rosser. It's all hearsay, it's too soon. Mr. Nelson categorically denies all the things that are alleged, et cetera. And we're not going to have a back and forth on that. The emails say what they say, and he either did or didn't reach out to the folks who told your client, yeah, this Nelson guy's reaching out to us saying, I'm with Mars now. And if those things, well, we'll talk about what I'm going to need from you, and you'll need to share with Mr. Rosser and Mr. Campbell in the short term. But having heard the discussion, are there more things you want to share on behalf of Tier 4?
I don't want to retread ground we've already been over. I would just say as an employee of Tier 4, he was aware of Mars and the competitive nature between the two of them when he went there. There's nothing more competitive than leaving and going to a similar role with a direct competitor, placing the same people for the same clients. I would say the Restrictive Covenants Act in Georgia very much militates in favor of granting an injunction under these circumstances, because the expectations of the parties were set forth in the agreement. I think it's narrowly tailored to protect both sides' business interest. He just couldn't go step on our toes by working for a direct competitor, placing the same people. It's true, they're correct. I've got hearsay. I don't have the documents yet, but based on what my clients have told me, I can get them.
Sure.
And
Well,
we'll get them. We'll have to get them if the case proceeds, of
Right.
course. But this is a preliminary injunction. It's a very short period of time, and I think that the RCA would support granting it under these circumstances.
Okay. The relief that you would envision, and forget about just the relief. Let's say you weren't seeking relief. Mr. Nelson going to a direct competitor isn't categorically prohibited by the non-compete. It would depend on what he did there.
Exactly.
Most obviously, if he went there just to be the CFO, it was purely financial, unless he was saying, hey, I know what the profit margins were like at that, but it was a different role. It wasn't talent acquisition. You're sad to lose him. Your client is sad to lose him, but he isn't playing the same role for Mars.
That's exactly right.
No issue there.
And I feel like it's a semantic distinction, though, what he's doing now versus what he did at our company. I feel like they're trying to make him look like he has nothing to do with sales in his new role as VP. But I don't think that the evidence will play that out. I don't have it yet, but that's
Okay.
not what we've heard.
Got it. And that's not the basis for your motion either, that it might look differently after a deposition, et cetera.
Exactly.
But just so I'm understanding the scope of the concern from your client, if Mr. Nelson at Mars engages very fervently and professionally and successfully in recruitment work, but it's not with clients of Tier 4 or prospects that he was aware of. Hey, I know Tier 4 is trying to get into the hospitality industry, and so they're going to work with Marriott and Hilton, et cetera. You know, if it's nothing like that, but it's now agribusiness, and Tier 4 just doesn't do agribusiness, then that's not an area of concern or part of the complaint here.
That's exactly right. I mean,
Okay.
this is a very niche industry, IT placement, IT professionals. This is not a broader agency than that.
Okay. IT. All right, that's helpful. Here's what I'd like. I would like you, Ms. Noble, to acquire, if you can, the email or emails that would support paragraph 12 of Ms. Robinson Hicks' affidavit.
Okay.
And get those obviously to opposing counsel, both of them, but also to Ms. Niles. You know who that is? Okay. Similarly, and I just don't know how this works, but it's up to your client. Subsequent paragraphs involve people relaying through the affidavit, and it's several layers of hearsay, but they ultimately, if you push back far enough, it is a Northwestern Mutual person saying, Mike Nelson said X, and that's not hearsay. Mike Nelson said X. So insofar as your client can get you, whether it's an affidavit or something from Northwestern Mutual people saying, I know Mike Nelson, and after he went to Mars, he told me X, but not it's raining in Omaha, but hey, I'm the guy who's going to help you with recruitment. That is about much of a bullseye as you're going to get, short of dragging people in here. And as much as Mr. Campbell wants to cross-examine people, that's going to happen at a later day. I am comfortable working off of affidavits that are a little less hearsay laden, which is not a knock on this. You put together what you could in the short amount of time. But if we're getting into that space, then I am more comfortable turning to weighing the elements that I need to weigh to think about temporary, preliminary, cautious, extraordinary injunctive relief. And obviously, Mr. Rosser and Mr. Campbell, should these materials slide across to you all, I'd give you a moment to digest them. And then I don't know that we have to get back on a Zoom, although I'm happy to do that. But at a minimum, you'd be able to send a reply to Ms. Niles saying, those are interesting, but what about this? So this is not a unilateral, once Ms. Noble gets this, we're done. It'll always be a give and take. I just don't know that we'll need to get a court reporter in here and have another hearing, but we can talk about that. It may be when you receive these things, if they exist and they're supplied, that then, Mr. Campbell, you say, I got to put Mr. Nelson on the stand. virtually. You don't need to be here, but you need to hear from him because there are explanations for what these Northwestern Mutual people are saying he told them. Assuming some Northwestern Mutual person will actually step up and say, here's my affidavit. Mike Nelson called me and sent me a Mars coffee mug. Here's a picture of it.
And I will say, Your Honor, I understand what you're asking for. It will have to come out as the case proceeds. It's awkward to ask a client.
100%. Right. And I get that. And so you may say undeliverable to those things. And you can explain to your client why I share the concern that Mr. Campbell does, which is it's a layer removed. And what was relayed from someone to Rampy to Robinson Hicks, it could have been blurred in the translation unintentionally. And Mike Nelson actually said nothing, but the CEO of Mars said, hey, we've got this great guy, Mike Nelson, who's actually our strategic leader. And so he's able to help if you want advice on strategies for recruitment, which could potentially be different from what your client is surmising Mr. Nelson is doing. Okay. So I realize the awkwardness of it. And Ms. Robinson Hicks may say, I don't want to do that right now. The relationship is delicate enough that I'm not going to say, create this affidavit or however you guys want to work through that. Okay. How much time would you like, Ms. Noble, to gather what you can and report back on the things that you, at this point, are not going to be providing?
Could I have till September 2nd, Your Honor, after Labor Day?
Yeah, just know that, and let your client know, I won't be doing anything with your emergency motion until I get what you provide.
And if we can get it sooner, I will get it for you.
Okay. I'm just looking at a calendar here. So sure, why don't we say September 5? That's 3 weeks from today.
Perfect.
Okay. So Mr. Campbell, I don't plan on doing anything more with the emergency motion unless people reach out. Before then, something could change. I mean, Ms. Robinson Hicks could say, here, I've recorded a phone call. I pretended I was Northwestern Mutual. And Mike Nelson said, here are the roster of recruitment services I'll provide you. And then we will react to that accordingly. But short of something like that, I'll just stay out of the way until Ms. Noble delivers something by the 5th. Does that work for you, Mr. Campbell?
Yeah, I have just one quick question for you, and I think I know what your answer is going to be. You want to wait until September 5th. Is it helpful to hear from Mr. Nelson what his job roles were at Tier 4 and then Mars at this point?
Sure, but whether you want in 5 minutes to do that with his testimony, or you want to put together an affidavit if that's not already in the affidavit, either way is fine with me.
The reason I'm hesitating is because if we don't get any emails, it's a waste of time. So I guess if Mr. Nelson, if you're okay with coming back on September 5th, I wouldn't want to waste anyone's time.
Okay. And I'm not saying on September 5th we're having a hearing. September 5th is the deadline for Ms. Noble to get us these materials. And so what I then would do, whenever she delivers, whatever she delivers, if it's a goose egg, then we may be done. But if she delivers some things, I'm going to give both you and Mr. Rosser a few days to digest them. And one of the things you may request coming out of that digestive process, Mr. Campbell, is, hey, Judge, can we have 15 minutes on a Zoom call? I got to get you to listen to Mr. Nelson about his role at Tier 4 versus his role at Mars. And it will put into context some of these things you've just received, because Judge, you're right. On paper, this looks problematic vis-a-vis the restrictive covenants, but hear from Mr. Nelson, and I think you'll be less alarmed by whatever it is, assuming something comes across the transom from Ms. Noble.
If that's the case, then yeah, let's go ahead and wait, because I don't want to waste anyone's time to the extent nothing comes up. So that's fine with me, Your Honor.
Okay. Mr. Rosser, your thoughts?
That sounds fine. I think that's a good plan. The one question I would have is as far as response time from when Ms. Noble provides the supporting materials. Does the court have a preference on timing of responses?
So it depends on what the response is. If Ms. Noble provides 3 emails and each email is 1 page, I'm going to need to hear back from you real soon. It won't be on the 5th, but I'm not going to say, great, you have 3 weeks to digest these 3 emails. If she provides 14 affidavits and 700 emails, then we'll talk in a few weeks. It's not going to be the latter, but it really is contingent on that. And I'll have my own sense when I look at it, like, you know what, we don't need a hearing. Absent, again, I won't refuse it. If Mr. Campbell says, you know what, Judge, this will be better understood by everyone if Mr. Nelson can testify about X. And then we can create an opportunity, just like we did today, for that to happen. But we're all doing what Mr. Campbell doesn't want us to do, which is speculate and infer, because we haven't seen what Ms. Noble is going to be able to produce. So let's see what that is, and then we can collectively come up with a plan about how we're going to process it.
The only reason I bring that up is because I'm actually I haven't filed a notice of leave of absence for this case since we just entered, but I'm actually going to be in Japan from September 5th through the 14th.
Okay.
So I just wanted to make sure I wasn't going to run afoul of something.
Got it. Will you be working in Japan or leisuring in Japan?
Vacation for the first time in a few years.
Okay.
So,
Well, we will not burden the vacation then with something that has to happen in connection with this case. And it may be that's the time Ms. Noble asked for as a deadline. She may decide, hey, I got 3 things on Monday the 18th, so I'm going to circulate those right away. And that may be enough grist for the mill for me to say, Mars, you got to try to explain this one for me, because otherwise I think I know where I'm going with it.
And I will say, Your Honor, we've been working very well together, so I think we'd be able to like hash out the deadline. So everyone's been very pleasant. So long story short, I agree we'll not mess up Chris's vacation, but we will be accommodating one another.
Okay, good.
And so will I, since I'm on the other side. So.
Good. Well, let me just close with this then, unless anything else, Ms. Noble, on behalf of Tier 4?
No, thank you, Your Honor.
All right, Mr. Rosser, anything on behalf of Mars?
nothing further, Your Honor. Thank you.
Okay, and Mr. Campbell, on behalf of your client?
No, Your Honor. Thank you.
Okay, between now and whatever we do next, it would behoove Mars and Mr. Nelson to, if they haven't been violating the covenants, keep on doing that. But if there's any gray area, Mr. Rosser, you may want to counsel your client to have people stay out of that gray area. It will frustrate me if some of what Ms. Noble shares is something that happened after August 15th, because Mr. Campbell has said every which way, Mr. Nelson has done nothing wrong. He understands what the restrictions are and he hasn't violated them and he never would. He's not that kind of guy. And that'd be great if that's how this plays out. It'll be tough for Mr. Nelson if it turns out that next week an email is going to Northwestern from Mr. Nelson saying, hey, how about this new hire? So just food for thought, because that could lead to more than just an injunction.
Understood.
All right. Excellent. Thank you, everyone. Have a good weekend. Appreciate you coming in late on a Friday.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, Mike, for showing up. I'll give you a call. Have a great weekend.
Bye-bye.
Oh, I apologize. Chris, you're still on? I
I'm
didn't.
still here.
Okay, I didn't introduce the 4 exhibits into evidence. Do I need to do that now? Or is that assumed since I emailed them to Ms.
They were part of the affidavit?
Yeah, everything I've already
Yeah,
submitted.
they're in the record
Okay, I just wanted to be sure.
for this proceeding, so
That's all.
they're good.
Okay, thank you.
Okay, all right.